So my case is Crane versus Hendricks, but before I talk about my case, there's another case that pertains to it, which is Kansas versus Hendricks. Leroy Hendricks was getting ready to be released from prison for child molestation, and the state of Kansas tried to get him committed under the Sexually Violent Predator Act. And he testified and agreed with his diagnosis of pedophilia and stated that he is very likely to molest children again once he gets out of prison. Because of his diagnosis and statement that he would molest another child, he became a candidate for civil commitment under the Sexually Violent Predator Act, which provides institutionalization of persons likely to engage in predatory acts of sexual violence brought on by mental abnormality or personality disorders. Hendricks appealed the validity of his commitment, as well as claiming that the state was unconstitutionally using ex post facto and double jeopardy law to the state Supreme Court. The court ruled that the act was invalid on the grounds that the condition of mental abnormality did not satisfy the substantive due process requirement that involuntary civil commitment must be based on the findings of the presence of a mental illness. The Supreme Court ruled against Hendricks in a 5-4 decision. It agreed with the Act's procedures and the definition of a mental abnormality as a congenital or acquired condition affecting the emotional or volatile capacity which predispositions the person to commit sexually violent offenses to the degree that such person is a menace to the health and safety of others. It agreed with Kansas that the act limits persons eligible for confinement to persons who are not able to control their dangerousness. And further, the court decided that the act does not violate the Constitution's double jeopardy prohibition, nor the ban on ex post facto law, because the law does not establish criminal proceedings, and therefore involuntary confinement under it is not punishment. Because the act is civil, Hendricks' confinement under the act is not a second prosecution, nor is it double jeopardy. And finally, the court said that the act is not considered punitive if it fails to offer treatment for an untreatable condition. Okay, so my case, which I said before, is Crane versus Kansas. Michael Crane pleaded guilty to aggravated sexual battery for 2 incidents on the same day in 1993. And the first, Crane exposed himself to a tanning salon attendant, and half an hour later, he exposed himself to a clerk in a video store and demanded she perform oral sex on him and threatened to rape her before he left. After Crane's guilty plea, the state petitioned to have him evaluated and deemed a sexual predator under the Kansas SVPA, which permits the civil detention of a person convicted of any of the several listed sexual offenses if it can be proven by reasonable doubt that he suffers from a mental abnormality. Mental abnormality just means a disorder affecting his emotional or volatile capacity, which predispositions a person to commit sexually violent offenses, or a personality disorder, either of which makes the person likely to engage in repeated acts of sexual violence. Several psychologists examined Crane and diagnosed him with exhibitionism and antisocial personality disorder. One psychologist stated that the 2 diagnoses placed Crane within the listed sexual disorders covered by the SVPA, and another stated that his behavior was marked by impulsivity or failure to plan ahead. And this indicated that the combination was willful and like added to his uncontrollable behavior. The court decided in a split 7-2 opinion that the Constitution does not permit commitment of the type of dangerous sexual offender considered in the Hendricks case without any lack of control evaluation. They also concluded that the Kansas Supreme Court interpreted the Kansas versus Hendricks case too restrictively when they ruled that a sexual offender who has only an emotional or personality disorder and not a volatile impairment must be found not to have the ability to control dangerous behaviors. The required standard of proof had to be sufficient to make the distinction between a dangerous sexual offender whose serious mental illness or abnormality made him eligible for civil commitment. But however, the court concluded that an absolute finding of lack of control was not necessary, since otherwise there would be a risk of bearing the civil commitment of some highly dangerous persons suffering several mental abnormalities. This is important for forensic psychology because this ruling will make it just a lot more difficult for states to place sexual offenders in civil confinement after they've served their sentence. And just like in the Hendricks case, they'll probably try to say that it was unlawful or try to just get it thrown and dismissed. And I mean, that can be a case, and if that is the case, then what they went to jail for, they could do it again and again, and then that's just more people getting hurt.